Welcome to this special show, and we're going to discuss a very important announcement that came over the weekend. The Government of India has effectively suspended fresh bankruptcy proceedings against people that have been impacted because of the COVID-19 pandemic for at least a period of 6 months that can be extended up to a year. To this effect, a new Section 10A has been inserted into the Bankruptcy Code that also says that no bankruptcy action can be taken against COVID defaults on a permanent basis. Section 7, 9, and 10 that deal with initiation of proceedings by creditors, by operational creditors, and by corporate debtors themselves has also been suspended. The cutoff date, of course, is March 25th. To discuss the implications of this very important regulation, we're joined by two very special guests, Mr. MS Sahoo, the chairperson of the Insolvency and Bankruptcy Board of India, and a top corporate lawyer, Mr. Cyril Shroff, managing partner at Cyril Amarchand Mangaldas. Thank you very much, both of you, for joining us here today. Mr. Sahoo, if I may start with you first, what is your general reading of these amendments? How should industry react to it?
See, essentially, this Insolvency and Bankruptcy Code is designed for two purposes: to deal with stress arising from competition and arising from innovation. From competition means that a firm is not doing well while all other firms in the industry are doing well. This is a question of financial stress. Firm is not able to compete with others. So IBC addresses such stress by allowing a more competent, more successful person to come in, take over the company and manage it. The other situation is that the entire industry is not doing well, probably because of the policy change, mostly on account of innovation, what we call creative destruction. So these are the cases where companies are in economic stress and these need to be liquidated and entrepreneurs to be released. These are the purposes IBC provides a market mechanism to rescue a company which can be rescued, that is in a failing but viable firm in financial stress, and closing a company which is in economic stress, failing as well as unviable. So this law is strictly designed to deal with when a firm is in problem, an industry is in problem. You can use it also when an economy is also in problem. But when not only one economy, every economy in the world is a problem, this IBC code is strictly not designed to meet that kind of need.
Yeah.
Like the situation today is that there is an airline industry who's for last 4 months having no business absolutely. You want to bring that company to insolvency resolution process, and this typically requires a right knight or savior to save this company. Where do you get a savior? So that means if you choose these otherwise viable companies, the purpose of insolvency law is to rescue the lives of companies. But you can't use this to take away lives of the companies.
But Mr. Shroff, if I could bring you in as well, initially the fear was there would be a blanket suspension. At least that has been done away with. There is a clear cutoff date with a clear timeline. But if you could tell us what was the rationale behind the introduction of 10A that permanently bars insolvency for defaults in this period?
Yeah, I think that's an interesting question, but I think they have done the right thing. So there is a clear sort of white line. At both ends of the specified period, as they call it. So I'll just take 3 dates: 24th March, 24th September, and 26th September. So any default that occurs up till 24th March, you can still act upon it. If it is 24th September, which is the last day of the 6-month period from 25th March till then, that is suspended in this specified period. And from 26 September, unless the period is extended by another 6 months, you are back again to the status quo ante. So this period has effectively been anesthetized, as if it sort of didn't happen from a default point of view. Now there are a number of routes which I think could have been available to the government. There was a conversation even before the actual ordinance came of trying to define a COVID default, and then you got into the question of what is a COVID default. So I think even though there may be some unintended consequences, I think they've done the right thing. Right? Because at least it's very clear, black and white, they've taken a knife at both ends, and demarcated the period, and at least it will reduce sort of areas for interpretation and controversy.
Mr. Sahoo, these unintended consequences that Mr. Shroff has spoken about, how can those be avoided? While there are genuine borrowers that will be impacted and must be protected, what about the truant borrowers that just game the system to take advantage, because bankruptcy proceedings can never be initiated for defaults in this period?
I don't think insolvency law is to deal with all malpractices happening in the system. Every law is made assuming that everybody is a responsible person, law-abiding person, and transactions are carried out in a free and transparent manner. Every law can be misused by some person, and there are always some miscreants can create problem. I don't think just to penalize or prevent some minority, few people who may indulge in malpractice, we can't deprive 99% of well-meaning people. Here the question is not a debtor and creditor. Here the question is saving the economy of the country. I gave you the example. Take, let's say, the restaurant industry. If all 10 lakh restaurants in the country are in problem, you want, or every hospital is closed now. If you push all of them, you have to see what is the consequence of this. The consequence is there won't be enough resolution applicants to take over the companies. These will be prematurely pushed into liquidation. But if you do not have it, what is the consequence? Is that some zombie companies, some unviable companies will continue in the system for a little longer time. They will not be.
But Mr. Sahoo, could this have been done using any other method? For instance, why not just simply exclude that 6-month to 12-month period from the total timeline under IBC? Why permanently suspend it?
So this is an unusual situation. What is suspended is only the default happening during this period. And this default has happened completely out of context, beyond the control of everybody, for which one cannot be penalized. Yeah, that's all.
Well, Mr. Shroff, coming to you then, what is your reading? What are the alternatives that could have been, introduced to make the system more watertight to prevent these truant borrowers from misusing the system?
So if I can build on what Mr. Sahoo said in terms of, the path that was chosen, and yes, it is an unusual provision because during the specified period, the default has been suspended, it has been suspended forever. So let's see what some of the other countries have done. The other countries have done what you were saying in terms of limiting the filings during this period. So you could bring a proceeding, but eventually when the period ended, the so-called specified period ended, you would be able to resume and even rely upon a default that happened during this period. But the way we have drafted our Section 10A is that this is not a default forever. Now, both I think are valid routes, and probably on balance, I think we took the right route as far as India is concerned, given where our insolvency regime is. And personally, while there will be some unintended consequences and some abuse, I don't think it is going to be so rampant because there are many reasons for it. One of which is that this 6-month period is also coterminous with the RBI moratorium period as well. So nothing was going to happen anyway. So therefore, if you were to sort of look at this period, what other route could have been taken? We could have taken the route in some other markets where you just only suspend the remedy but not the underlying default, or you suspend the underlying default itself, which is in any case coterminous with the suspension of the remedy because of the moratorium. So it's unusual, but it's not too bad.
But Mr. Shroff, what happens at the end of this, say, up to 1-year period? If the default is continuing, can creditors still be precluded from initiating insolvency proceedings in future?
If it relates to a default during this period, then
if it is a continuing default, if after this period as well the default continues, what happens?
But that time there is a fresh default. So you will not be able to rely on, for example, the default which occurred on 26th of March. But if there is a fresh default on 26th of September or the 1-year period thereafter, say 26th of March next year, then they will be able to rely upon it. But this is, as I called it, this is the anesthesia period where you can't, it's gone.
Well, Mr. Sahoo and Mr. Shroff, please hold your thoughts. We have many more questions, but we have to slip into a short commercial break. We'll be right back. To you, while IBC is suspended, SARFAC continues. So, for instance, if a creditor still wants to take that route to resolve debt, there is no protection available, to the corporate debtor from security enforcement, from moratorium. What happens in that scenario? Where is the protection that was available under IBC then?
See, the menu available for banks in case of default is quite long. If they are interested in recovery, IBC is not an option for them. They may resort to that recovery of debts in Bankruptcy Act, to SARFAC, and many more only when they are interested in resolution. They have again options to use the statutory court-supervised process, compromise or arrangement under the Companies Act 230 of the Act. They may use the 7th June RBI directive for resolution of circumstances. They may sit across a table and work out a solution. It's said that the necessity is the mother of invention. I'm sure they all would find out new ways of arriving at resolutions. So our only objective was that a company's life should not be taken away prematurely, because IBC necessarily leads to, if there is no resolution applicant, to liquidation. If creditors want to avail of any other remedy, let them avail, and debtor is under obligation to meet discharge his own obligations. So idea is only,
But what are these alternatives? For instance, the problem with the June 7 circular is it is not binding on entities that are not regulated by the Reserve Bank of India. It's not binding on the Government of India, for instance, if that is a party, on mutual funds, and several other, involved parties in a resolution.
I think we should not be looking for always that some external things should come and bind us, then only we will arrive at a solution. I can't get debtor and creditors sit at the table and say that this is the way to resolve. And it is not necessary that resolution necessarily means restructuring of a debt or taking a haircut. Resolution can mean introducing a new technology, can mean a capital infusion. So there are many innovative possibilities of a resolution. So I think this is the time when IBC is not available. People should explore newer and newer options of resolution.
Mr. Shroff, I also wanted to touch upon Section 10, which is also being temporarily suspended. Is it right to prevent genuinely distressed borrowers from filing for bankruptcy themselves? Will it not add to further distress in the absence of this section?
Yes, but I just want to first, before I answer that question, I just want to supplement what Mr. Sahoo said in terms of available options. One option which I think whose time has come is what is called prepacks. And IBBI had actually put out a concept paper about a year ago on this. And it's time for kind of taking it off the shelf, dusting it off and implementing it, because it serves both purposes. It allows sort of bilateral commercial innovation and negotiation to take place, and it also gives the imprimatur of kind of enforceability to it with the sort of stamp of the NCLT or whatever is the forum that is decided, and allows you to bind the minority as well, which may be holding up the entire process. So if I think the time for if there's any particular time when prepacks has become important, I think it is now. So I just want to just supplement what Mr. Sahoo said. Now your second question on Section 10, which is basically essentially the right to die for the corporate or for the corporate debtor. So that has been suspended, and that's again a little different from what is the position in the rest of the world, where all the bankruptcy that you read about in the US, they are all in the exercise of their equivalent of Section 10, where a debtor could go to the bankruptcy court and seek the protection of the bankruptcy court from hostile proceedings by creditors or by people who want to attach their assets, and during that moratorium or protection period, reorganize themselves. So that has been suspended. But the one thing that has not been suspended is the right for voluntary winding up. I think Mr. Sahoo referred to that briefly as well.
Yes.
So you could do that. So even if no default has occurred, nothing prevents a company from initiating a company law voluntary winding up, and it can get you roughly to the same point.
Well, we're running out of time. Quickly, Mr. Sahoo, if I may bring in the MSME bit as well, which the finance minister alluded to. A new framework is expected. What should we expect on that front, especially in the context of Section 9 also being suspended? A lot of operational creditors are also MSMEs whose rights have been taken away in the 6-month period.
Yeah, the MSMEs have a dual role in IBC process. They come as a corporate debtor, they come as also an operational creditor. The first objective was that let a MSME not get forcefully into this process. You need to have a height from the threshold from 1 lakh to 1 lakh. As regards the operational creditors, again I told you, a creditor has several other rights. As an operational creditor, they are more focused on the recovery, and they have several other laws in the system to use and get that done. As if I can elaborate a little more on what Mr. Shroff told to the suspension of Section 10 and pre-pack and MSME altogether. The objective of this law is not to protect a debtor or creditor, but to protect the economy. Whether you want to approach a problem through 7, 9, or 10, the ultimate end destination is closing a company. That is not intended. Even in IBC also provides, if you are in good health, please go for voluntary liquidation. There is a framework under this law.
Well, just concluded comments from you as well, Mr. Shroff, picking up from Mr. Sahoo also said, but broadly, how would you sum up? I know the objective is not to serve one party or the other, but is it more biased towards the borrowers than the creditors, the suspension for the next 6 months to a year?
So temporarily, yes, during this specified period, whether it is 6 months or 12 months, a little bit of the power has shifted back from the creditors to the corporate debtor. But that's okay, because I think as Mr. Sahoo said, this is about the economy. This is not about borrower and lender. And I think there are broader policy implications on this, and other routes are available as well, such as pre-packs, voluntary liquidation, schemes of arrangement, SARFACI. There's a long list of things which have not been touched at all. But I want to leave one final provocative thought on the table for thinking about, and I think the foundation of that is in the preamble itself. So one of the reasons and rationales for this ordinance is that there are not likely to be adequate number of resolution applicants,
absolutely,
to secure the corporate person who may be in default. So is this time to rethink 29A? I'm not making a case for the willful defaulter types, but I think this is actually a recognition of the fact that we need to relook at 29A, and actually will bring back a whole host of good promoters who could actually use.
Let me actually quickly toss this back to Mr. Sahoo as well. Mr. Sahoo, do you agree Section 29A should be temporarily suspended in these uncertain times? At least we'll have some participation from proven promoters of companies. Okay, I think we've lost Mr. Sahoo's line there, but Mr. Shroff, thank you very much for your thoughts. We'll wind it up there. And okay, Mr. Sahoo is back. Yes, Mr. Sahoo. Do you think Section 29A should be temporarily suspended as well, as Mr. Shroff is putting it?
But not for willful defaulters. I'm making a difference between the good guys and the bad guys.
Oh, well, okay, Mr. Shroff, we'll leave it at that. Both of you, Mr. Sahoo and Mr. Shroff, thank you very much for joining us in this very special discussion. With that, we're to the end of the show. Many thanks for watching.